Hey, everybody, welcome. Better late than never to Thursday night. Hey, everybody, John Skiba here from the Consumer Warrior YouTube channel. We are back like we are each and every Thursday night to talk about all things debt related, whether it's debt collection lawsuits, bankruptcies, or all the other horrible debt related things out there. We're going to talk about some solutions, resources, tips, strategies. We're going to do Q&A. If there's questions, that's what I like to do on the channel, is to address those and give you some, tips and strategies, like I said, of what you can do to get those dealt with. My name is John Skiba. I am a bankruptcy attorney and a consumer protection attorney in the state of Arizona. My information is scrolling along the screen here. If you're in the state of Arizona, I'm happy to see how I can help. I do consultations with Arizona residents. If you're not from Arizona, I have the channel. I have the Consumer Warrior University, which is there's a link to that in the comments section. You can take a look at that. I often get people when they call in for consultations, they say, "Are you the guy on YouTube?" And I'm like, "Yep, it's just me." I do work for the law firm. There it is, Jackson White. There's about 30 attorneys. We do everything from criminal defense to bankruptcy, family law, all that kind of stuff. But with the bankruptcy department and dealing with debt collection lawsuits, it's me and my staff. And so if you call in, you're more than likely just going to be talking to me for good or for bad. So the way that we do this each week is if you have questions, if you have topics that you want to talk about, go ahead and put them in the comment section, and then I will address them. I'll do the best I can, I should say. My little asterisk that I put each and every week is that while I am a licensed attorney in the state of Arizona, not licensed anywhere else. And in October, I've been practicing for 20 years in the state of Arizona, and I'm not going to get licensed anywhere else. I always said, but after I passed the bar, I'm like, I'm never doing that again. And I haven't. I've kept that vow. I'm not taking another bar. But if you have questions, go ahead and put them in there, and I can at least point you in the right direction. So something I like to do each week is I go over to the comments on the YouTube channel. Like I said, the channel has grown to the point, gosh, I think we're like at 35,000 subscribers. We're getting closing in on 3 million views. There's a ton. I get hundreds and hundreds of comments each day. And so because of my day job, I can't respond to all of them. But I do like to pull some of the comments out and go over them and kind of discuss it, because I think that when there's some general applicability there. So I wanted to talk about this one here. This person said, I like this comment, just simple. How bad is the process of Chapter 7? I can tell you with Chapter 7, in most cases, it's way better than, well, I guess I should phrase that differently. It's a lot less traumatic than you're thinking it's going to be. A lot of people feel that no one wants to file bankruptcy. I always say that. It's something where something's happened, or, it can be just bad choices. It can be something happened with medical bills, and all this kind of stuff just piles up, and you need to file for bankruptcy. A lot of people are worried about the judgment of the court, or the judgment even of me as an attorney. That is not really there. Really, it's more of just I always say it's more like a math problem. If you qualify for a Chapter 7 bankruptcy, they're just looking to see if you have assets coming in, assets going out, whatever they need to do to process the case and push it through. I can tell you, in most cases, the amount of stress and everything that you dealt with, one of the things that people tell me is, boy, I should have done that a long time ago, because the stress that you're dealing with the debt in almost every case is 10x what you're dealing with through the bankruptcy process. Not only that, but you recover a lot more quickly through it. So that kind of feeds into this next question that was on there. This person said, I need some feedback. I have 5 lawsuits for credit cards. Debt I ignored because a friend told me not to worry about it. Bad mistake. That's one thing I tell on the channel. The one thing you can't do, whether it's a debt collection lawsuit or bankruptcy, is just ignore it. You got to deal with it head on, put a plan together. So they go on to say they are already in final default judgment, and the total debt is $25,000. This situation is very stressful for me. I own a house. I still pay. I do have a car. I still pay. I do not have any other assets. My credit score is 600. I live in Texas. I already contacted an attorney. I qualify for Chapter 7. I'm struggling financially to pay all my bills, so I'm not able to offer any settlement to a collector company. I do not want them to freeze my bank account. Thank you. So, each case is different and is very fact specific, but the facts here that help me to say that, bankruptcy is not a bad option. And I'm glad to hear you're talking to an attorney there, because they're going to be able to guide you specifically in Texas as far as how the process plays out. But if you qualify for it, if they have the default judgments, that's one of the keys here, that you put that there's $25,000 and they already have final default judgments. The reason why they want the judgment is because in most jurisdictions they can garnish wages. I believe in Texas there is no wage garnishment. But even with the default judgment, they can often do bank levy, they can lien real property. So once it's advanced to that stage, then bankruptcy becomes a little more pressing. It's usually the garnishments, the lawsuits that kind of push people over the edge as far as that decision-making process to be able to decide to actually get, to move forward with it. So, and like I said, the main thing here, like you were saying, it's a very stressful situation. In almost every situation with secured debts, like home loans, car loans, in most situations, you can keep those as long as you keep the payments current on it. So, my recommendation, I'm glad you're talking to the attorney, find out what the exemptions are. They can let you know for sure if you're at risk of losing anything. And it's going to be, trust me, like I said, the stress you're dealing with now compared to what the bankruptcy will be, it'll be night and day. It'll be a lot better situation, just be able to get it taken care of. So, all right. So the way that we do this, like I said, you go over to YouTube. If you have a question, put the comments in or question in the comment section. I'll put it up here on the screen and we will talk about it. All right. Let's see what Christine says. What should I do to stop collection agencies from adding interest charges to my original medical bill that is below $500 right now? So, interest is it's one of those things that can just be, I guess it depends on which side of the equation you are. If you owe interest, there's those quotes, the interest never sleeps, it never takes a break, it never takes holidays, it doesn't take weekends off. It's continually accruing. And so the interest rate for most accounts, whether it's credit cards, whether it's medical bills, it's contractual. Whatever agreement you signed with the hospital, with the credit card company, those are the interest rates you're going to pay. And sometimes they change. Like when it comes to credit cards, you might have like a credit card with like a 3% interest rate, but then as a default rate, if you stop making payments and the card goes into default, all of a sudden it jumps up to 29% or even higher, like 34, 35%. And then that interest continues to churn 24 hours a day until the debt is either settled, paid, or you file for bankruptcy and eliminates it. So the collection agencies, I can tell you this, if you're trying to settle the debt, and particularly if you're trying to settle medical debt, I have found that medical debt is one of the ones that's a little easier to settle. There's certain restrictions and requirements as far as like the credit reporting. I believe it's 4 months, maybe it's 6 months. It has to be delinquent before they can report you to the credit reporting agencies. You can negotiate. They're never going to say, no, we'll agree that there's no more interest accruing. They're never going to say that. But if you're out there trying to settle it and you're offering them $250, I mean, that's a way to get it to stop. You need to get it settled. You need to get it dealt with, whether it's settlement, whether it's bankruptcy, whatever it is. That's how you're going to get it to stop, because they're never going to just agree to stop allowing it to happen. And truthfully, the collection agency and the people in the collections department, they're not going to have that authority anyway. This is something contractual that you signed when you signed up on the thing. So unfortunately, that's what you're looking at, getting it settled, getting it paid, or filing a bankruptcy on it. This one, Mr. Misunderstood, says, what is the statute of limitations on a family loan? It's a good question. So the statute of limitations is the amount of time from when a loan goes into default until you have it to file the lawsuit. So for example, in Arizona, the statute of limitations on written contracts and on credit cards is 6 years. So that means from the time that the loan or the credit card goes into default, the creditor then has 6 years to file a lawsuit against you. If they don't, then they're forever barred from trying to collect on that particular debt. At least they can't sue you. They can ask you to voluntarily pay, but there's not a whole lot they can do as far as forcing you. They're not going to get a judgment. They can't garnish you, that kind of thing. Now, it's important to know that the statute of limitations, that's different than if they already have a judgment. Sometimes people will call me here at my office in Arizona and they will say, hey, they have a judgment against me. The judgment's like 6 years old. Hasn't the statute of limitations run? How could they still try to collect on that? Statute of limitations deals with pre-lawsuit. There are statutes that deal with how long a judgment is good for. Like in Arizona, judgments are good for 10 years, and they can be renewed every 10 years for the rest of your life. So what we're talking about here is statute of limitations. It's also a very state-specific law. So there's not a federal statute of limitations when it relates to things like this. But what you need to do, Mr. Misunderstood, is you can Google it. Google Scholar is a great one to look at. Is you ought to look and see what just Google what the statute of limitations is. But the things you need to look for are like statute of limitations for a written contract, for an oral contract. Because if we're talking family loan, if your brother loaned you $5,000 and now he wants to sue you, in most situations like that, where it's kind of an informal loan, those are oral agreements. And so like in Arizona, the statute of limitations on an oral agreement is 3 years. It's a lot shorter. If it's in writing, it's 6 years. It's 3 years for an oral agreement in the state of Arizona. So that's something you might want to take a look at when you're doing your research on it. That'll give you a little bit more direction as far as which way you want to go with it. So, all right. Mick says, hi, I got sued by a law firm for a supposed old credit card debt. I answered that I did not know if it's mine, denying the allegations. What could happen next? So what'll happen, and again, I put a link to the Consumer Warrior University in the channel there. You got to check that out. I have all my tutorials, templates, forms to kind of walk you through this process. What'll happen next largely depends on the state that you're in. For example, and it is largely the same, but there's some unique procedures in each state. And even like in Arizona, like in the justice courts that deal with debts under 10 grand, Superior Court that deals with debts over 10 grand, the processes are somewhat different. But usually what happens is once you file an answer, so the complaint is their set of allegations, you've now filed your answer, which is your response to it. The court's saying, okay, we have a dispute here that we need to resolve. The case then goes into a discovery period. The discovery period is where usually initially there's a rule that requires the parties to exchange what are called disclosure statements. Essentially, both sides have to show their cards, witnesses, exhibits, documents, defenses. They have to show everything that they intend to use to defend or prosecute their case. There's no Perry Mason moments of, showing up the day of trial saying, haha, look what I have. You have to show well in advance, and that's what the disclosure process is. The case will then go into formal discovery where there's written questions, depositions, those types of things. There's usually what's called a pretrial conference, which is really usually when the court kind of really gets its arms around exactly what the case is about, and then they'll set out a trial date. Now, it can take forever. I can tell you, like even in the justice courts in Arizona, where they're dealing with matters that are under $10,000, it can take up to a year to get a trial date. Superior Court in Arizona, the average time from filing the lawsuit until you actually get your trial is about 18 months. If you're asking for a jury trial, it can be a couple of years. So I always say the wheels of justice move very slowly, especially when it comes to civil lawsuits. So, all right. As far as what happens next, that's typically what you do. What you want to look up is the rules of civil procedure, or you should go to the court's website. Particularly if it's like a small claims type thing, they will have a lot of their processes written out on the thing there. So, all right. There's follow up here for Christine. So, with Mick, you're in Montana. Montana's a great place. My uncle and aunt used to live in Ennis, Montana. It's actually where I went on my honeymoon, and we went up there and went fly fishing because my favorite movie is A River Runs Through It, about fly fishermen. I used to fly fish all the time as a kid, and then I moved to Arizona, and our rivers are missing a very critical element of fishing, and that is water. Most of the rivers here don't have any water, and it's crazy hot. We're in the middle of this heat wave right now. I was just looking on my phone to see what the temperature is. It's above me 111 degrees right now in Phoenix, and it's 5 o'clock at night, 5:30 at night, still 111. So if you're under $10,000, I would look at the court that it's in. They may have lay it out on their website, at least what their general processes are. Otherwise, you need to look at your the rules of civil procedure for Montana. So, all right, let's go back to Christine. She said this was the question she had about interest on the medical bill. Said there's no agreement between me and the original creditor regarding any interest. can the collection agency take my original bill and add interest? So what they may be doing, there is in most statutes, like in Arizona, there's a default. Basically what it says is, look, if there's no interest rate that is assigned in the contract, there can be a default rate of 10%. That's Arizona. And so that may be what they're doing. So what you may want to look at is, Christine, is in your particular state, is look and see what you can just Google these things. It's not going to be always 100% reliable, but it can give you just an idea maybe of where they're coming from, is if there is a default rate of interest in your particular state. So, all right, let's see here. Wife, Lowrider says, wife wants a divorce. We don't qualify for Chapter 7. Should we file for bankruptcy during divorce, and how will that qualify us for a 7 versus a 13? So this is a good question, something I run into quite a bit. So Chapter 7, you have to qualify for it. Yeah, you have to they look at your household size, the number of people in your home, and then the average income for your particular state. And some states, it's even broken down by county. And if you make more than the average family, then they could force you into a Chapter 13. Now, most people file Chapter 7. That's what most people want. It's a relatively short process. You don't have to pay any of the debts. They just get wiped out. It's kind of the fresh start bankruptcy. Whereas a Chapter 13 can be up to 5 years of paying back your creditors. So, however, and like in Arizona, it's a community property state. Even if one spouse is filing for bankruptcy, we have to look at the total household income. So we look at income from both spouses. However, if the parties are separated, and it's actual separation, it's not something, you're not living together anymore, you're maintaining separate households, then we do not have to count both spouses' income in that. And if you're divorced, clearly you can't file a joint case anymore, and we're just looking at your income separately. So couples that are separated, or if the actual divorce has been finalized, then we're only looking at one of their incomes, and then that individual person may qualify for a Chapter 7 based upon their income, when for as a couple, they did not. Should they file, the bankruptcy during the divorce? That question is as old as time for bankruptcy lawyers. You talk to family law attorneys, you talk to bankruptcy attorneys, everybody kind of has their own little take on it. Here's my take on it. I think that often it makes sense for couples to, if you know that the marriage is headed for divorce, there's a lot of debt issues, particularly if you've been married for quite a while and there's a lot of joint debts. It will make the divorce proceedings cleaner as far as dividing up the debts if the parties file a bankruptcy, and I recommend a joint bankruptcy if you can qualify for it, before the divorce is finalized. Because what you're going to see with the divorce decree is they're going to attach usually a division of debts in the final decree, saying that this spouse is going to pay this spouse is going to pay this. If you get the divorce decree, it's signed off, and then one of you files for bankruptcy, the divorce decree is not binding on your creditors. It's binding upon you and your spouse, your ex-spouse. It's a contract between you and your ex-spouse. But if you have an American Express card and it's in my name, and my ex-spouse says, okay, I'm going to cover that, and then they file bankruptcy, they're just going to come after me. They don't care. The creditor doesn't care who they go after. And the decree is not binding upon them. That's something that a lot of people don't understand as they're going through the divorce proceedings, is you're thinking, okay, husband says he's going to take all these debts. That's cool. Divorce gets finalized. They go, and then husband runs and files for bankruptcy. All those creditors then are going to shift back to the wife or the other spouse to be able to go after those funds. So it's important to understand that. You may have some remedies through the family court as far as trying to remedy that, but through the bankruptcy court, they're gone. And the creditors, like I said, they don't care. They're going to go after whoever they're going to go after to get those funds. So your question, though, is about qualifying for it. If you are separated or divorced, you may be able to qualify based upon, then they're just looking at your incomes individually. If it's possible to file a joint case, I always say that's a good option because it's cheaper. I know most bankruptcy attorneys, whether it's an individual or a joint case, they don't charge extra. And it's going to make the the final divorce decree a lot cleaner if all the debts have already been dealt with. And then if there's specific debts like a tax debt or student loan that was non-dischargeable in bankruptcy that you can take care of. So, all right. I think that'll do it today for this hot summer day. I'm going to brave out into the heat of and question myself, why do I live in this state? But hey, I appreciate you all checking in. Again, go check out the Consumer Warrior University. There's a link there. You get full access to the tutorials, templates. I've got some kind of exciting things I'm working right now to start incorporating some of the AI technology into that. It's going to make them even more robust and I think a bigger help for everybody who's involved there. But go check that out. A lot of great resources there. And with that, I'll catch you next week.